An executive order is not a law, but it can still bind the entire federal government. Understanding why that's true and where the legal limits are is essential to understanding modern constitutional government. An executive order is a formal directive issued by the president to officials and agencies within the executive branch. It tells the executive branch how to carry out existing law or how to exercise authority already granted to it. What an executive order does not do is create new law. Congress legislates, the president executes. That distinction matters. Every lawful executive order must trace its authority to one of three sources. First, the Constitution itself, such as the president's role as commander-in-chief or authority over executive personnel. Second, statutes enacted by Congress, where Congress authorizes executive agencies to act within defined limits. Third, a narrow zone of inherent executive authority, which exists but is closely confined. Executive orders operate within authority. They do not create it. Executive orders are not new. Presidents have issued them since the early republic. For much of American history, however, they were used sparingly, primarily for internal administration, managing departments, military operations, or implementing laws Congress had already passed. The shift begins in the 20th century. During the New Deal, World War II, and later the Cold War, Congress increasingly delegated broad authority to the executive branch. Executive orders became a tool for directing how that delegated authority would be used. In recent decades, as Congress has struggled to legislate, executive orders have been used more frequently, not because presidential power has formally changed, but because institutional incentives have. Those limits remain firm. An executive order cannot contradict a statute. If Congress has spoken, the statute controls. An executive order cannot appropriate funds. That power belongs exclusively to Congress. And an executive order generally cannot bind private parties without clear statutory authorization. When an executive order exceeds its lawful authority, it is not void because of politics. It's void because of structure. When disputes arise, courts do not ask whether an executive order is useful or popular. They ask whether it rests on lawful authority and whether the remedy imposed is appropriate. That is why executive orders often become the subject of injunctions and judicial review, and why remedies, not just merits, have become central to constitutional litigation. Executive orders are powerful administrative tools, but they are not substitutes for legislation, and they do not alter the constitutional allocation of power. Understanding their limits is essential to understanding how our constitutional system actually functions.